in the studio, 436-1212, the number to call if you have a legal question. Good morning, Charlie.
Good morning.
And an early happy July 4th to
Well,
you.
thank you very much. Same
Good
to
to
you.
have you on the show.
Right.
Thank you. We're going to go ahead and get on the phones right now. We have a caller on the line who has a very interesting question.
All right.
Hi there. What's your question for Charlie?
I recently bought a truck. I have full coverage on it, and I put insurance on it. My insurance company said that they couldn't put my boyfriend on it unless we lived together. We made a trip somewhere. He turned too sharp and hit some poles. He got the company, or when the title came back from Oklahoma, he got the dealer to put his name and or on the temporary title. I need the title back. I am no longer with him. The loan's in my name. The insurance is in my name, but he's holding the title.
Well, I don't, if the title's actually and or, either one, when you put a title and or, what that means is either one of you can sell the vehicle, put it in your own name, or do whatever you want with it. I mean, if you buy it together, that's a contract between the two of you. If you put a title differently, if you sell it to a third party, you have to sue each other. You don't sue the third party. If he hasn't gotten rid of it and it's still an and or, you could go down to the motor vehicle department and actually have it transferred into your name only. And that's what I would advise you to do if you bought it yourself. So you could do that if he hasn't already done that. But anytime somebody's in a relationship and you start buying things and putting them in different names, and that relationship might break up later, it can cause some real problems for a lot of things.
Well, in this situation, then, he would not be at fault legally if he were to go and sell it, because he does have control of the title.
Well, legally, but if he and she had an agreement, a contract between the two of them, I suppose she could sue him over the contract. Now, that might get pretty costly. I don't know how much the vehicle costs, but that could get costly real quick. But if you and someone else agree to something, that's a contract, and depending on how you do it, it may be a valid contract, and then you could sue the other party for what you and he agreed. So if it was half and half, you could sue him for that money. But it would be different than selling it to a third party. You could still sell it.
Okay, now you and I have talked before about verbal agreements and how important they actually are. If you say something to someone and you, shake on it, talk about it, I mean, how strong are they?
Well, you'd really have to have some consideration. By what I mean by that is you'd have to exchange money and then probably do the deal, basically. I mean, there's all kinds of variances in that in the law, but you'd really have to do something that would kind of harm both of you or make both of you gain, and then you'd have a contract that you could sue on. Obviously, it's better if it's in writing, but you can still argue about writing. And any real estate deal has to be in writing.
Okay.
The law says that.
Okay. Thank you, Charlie. We have time now for another caller this morning. Hi there. What's your question? Good morning. What's your question?
My question is, how does the grandparent go about getting a grandparent visitation right?
Well, actually, what they do is they need to go to the court, preferably with an attorney, I think, for something like that. And there's a statute that covers that. And you'd have to go to court and go in front of the judge. And if the parties agree, you can work something out. If they don't agree, the judge will make a decision. But that's something that can be decided and can be done. And we have grandparents' rights in this state. They're somewhat limited, but we do have rights so the grandparents can see their kids, because sometimes different parties that have been married to, for whatever reason, want to punish the grandparents as well as the ex-spouse or the ex-father or mother.
Do they have to go ahead and determine and validate, any type of relationship with the blood test before they can go through with that?
Well, I mean, if the people don't admit it or if they're not married, that would be true. But I mean, sometimes it's pretty obvious, even if they're not married, that the grandparents have been seeing the child for 5 years as a grandparent, and then if you deny it, it looks kind of silly, actually.
Okay. Thank you, Charlie.
Okay, thank you
so much for calling in today. Charlie is back here on Wednesdays if you did not get on the line today, and we'll see you next week.
Thanks a lot.
Okay, more Eyewitness News to come on KSCW. Stick with us.